All rise. Hear ye, hear ye. The First District Court of Appeal is now open. All who have business for this court, draw near, give attention, and you shall be heard. God save these United States, the great state of Florida, and this honorable court.
I call now the first case we're going to hear this afternoon, Jimmy Walters against the Florida Department of Corrections. Are you ready to proceed?
I am, Your Honor. For the record, my name is Paul Hawks. I represent Jimmy Walters. I would like to reserve 5 minutes for rebuttal. Basically, what we have here is a relatively simple factual situation. Mr. Walters, it was stipulated, was a member of the protected class. It was stipulated that he had heart disease. It was stipulated that he had passed his pre-employment physical, and it was stipulated that he suffered disability. As a result of these stipulations, Jimmy Walters qualified for the 112.18 presumption that his injury, his heart disease, was work-related. We go to hearing, and it's at hearing that this relatively simple, straightforward, factual situation gets distracted, gets deterred. And it becomes basically a burden on Mr. Walters to show, in spite of the stipulation, it almost seems like the JCC and the EC pick up the stipulation and set it aside and say, Mr. Walters, prove your case. And in reality, he was unable to prove his case under major contributing cause standards or under the typical workers' comp standards because he had the presumption. And with the presumption, it was not his burden to prove. Under the presumption, it was the employer carrier's obligation or burden to prove, with evidence, meet the same standards as Fuller sets out, that the claimant would have to normally prove if he didn't have the presumption.
Counsel, a question for you. What exactly did the presumption cover? Did it simply cover that the claimant had suffered pericarditis, or did it also cover the fact that a virus caused the pericarditis?
Your question is interesting because, you know, there is a possibility that had the employer carrier not stipulated to the presumption, if they had come in and made a different argument, they may have been able to prevail. But what the presumption covered was his heart disease was compensable. His myopathy heart disease was a covered condition. And so for them to rebut that once they stipulated it to, they would have had to prove that the virus, which, and if we take the facts most favorable to them as the prevailing party, they had perhaps established that the heart disease was caused by a virus. So therefore, they would have to go one step further and prove that the virus was caught someplace or he was exposed to this virus someplace that was not work-related.
Well, is there something in our decisions, past decisions, that would support your position? Because it seems to me that it would be virtually impossible, particularly for a condition that's caused by a virus, it would be virtually impossible for the employer carrier to have overcome the presumption that the virus was contracted at work.
There is. LeBanc, I think, is a case that clearly addresses it, where the court said that you can't just prove the physiological cause, you have to prove the legal cause. It wouldn't necessarily be impossible. Obviously, it would be difficult. You know, you can reasonably think of factual situations where the virus could only have been caught if he hadn't been at work. Maybe if they had just recently adopted a child and took the 6 weeks of family medical leave, and he had not been in contact with his workplace, and you consider, you know, and the doctors testified that there is no way that he was exposed to this virus at work because he wasn't at work, and the incubation period for this virus is 3 to 5 days. You know, that is a possibility. Now, of course, they didn't do that, but it would be very difficult for them to prove. But that's the purpose of the presumption. It would be very difficult for the claimant to prove, if he had caught this virus at work, that he had in fact caught it at work, because as the doctor said, and as the EC says in their brief, you can get it anywhere. And as he could have caught it at work, he could have caught it not at work.
If
So-
the purpose of this presumption is to provide, of course, a presumption of occupational causation for employees in a profession that is high risk, where they are exposed to extreme stress and danger, how is that policy effectuated here when the cause of the heart disease is a common virus that all of us have had probably at some point in our life?
Well, you know, this happens to be a common virus was the terminology, but it's very uncommon that a virus results in heart disease. This is a fairly rare result. But of course, you know, Caldwell was a case of arterial sclerosis, hardening of the arteries, plaquing. You know, frequently plaquing, hereditary. You know, who are your parents? What's your lifestyle? What do you eat? Do you smoke? Do you drink too much? These are perhaps far greater causes, but the legislature has decided as a matter of public policy on these difficult cases to show, for these groups of people, we're going to give them this special advantage, this special benefit. And maybe they feel it's necessary to recruit. Maybe they feel it's necessary to say, I mean, for whatever reason, they have offered it. They have stipulated that we qualify. Once they stipulate that we qualify, then the only question becomes, can they prove, with the same burdens that the claimant would normally carry, proving that their claim is compensable, they have to prove it's not compensable. They have to prove, you know, perhaps through blood studies or through other factual development, that the claimant did not come in contact with this virus at work. They did not do that. There is no evidence in this record, much less competent substantial evidence, to support a finding that this is a non-work-related virus.
All right, so your position is that because he was a correctional officer, because he came down with cardiomyopathy, which had not been discovered on a pre-employment physical, that he has the benefit of this presumption, and now you say that the employer can overcome that presumption with appropriate proof, just that they failed to adduce that proof here.
Right. The presumption is a rebuttable presumption. Now, of course, Fuller says that they have to meet the same standard that the claimant has to meet. But yes, they can.
What is the standard? What would be the standard that the employer would have to meet?
Well, of course, in this record, there's none. And under Punske, of course, this court, and Punske is an interesting case because the presumption was overcome, and it was overcome in presumption, Punske, by a congenital condition that the claimant only caught because of who his parents were, not because of where he worked. And the court allowed the presumption to be overcome in that case. Clearly, those are not the facts here. I'm sorry, I drifted and I forgot your question.
Well, what is it that the employer must prove?
The standard of proof, yes. Well, Punske, the court said that if there is evidence besides if the claimant offers the presumption and then additional evidence, then the employer carrier would have to come up with clear and convincing evidence.
Clear and convincing evidence of what?
Non-occupational causation.
Non-occupational causation. And here the doctors all agree that the heart condition could be traced to a virus.
Right, just like the doctors would agree that many heart diseases can be traced to plaquing.
Well, didn't he come down? Wasn't he on vacation when he presented at the hospital complaining of chest pain?
He was on day one of his vacation. He had gone to work. He reported that he had felt bad for 3 days earlier. That's in the record. He had finished his work on Friday. Saturday and Sunday were his normal days off in his work week. Monday was the first day of his vacation, and he reported to the hospital. You know, clearly, even to the extent that...
He reported to the hospital on Monday or on Tuesday?
Well, it was the first day of his vacation, beginning right after his normal 2 days off, and I might be thinking that most people get Saturday, but obviously corrections officers don't. But if that were possible, and perhaps if they had developed that line, they could have proven it. But here, of course, there's no evidence in the record that he got this anyplace else, just that he was exposed to a virus. If they wanted to develop that he wasn't at work for 3 days and therefore scientifically speaking, it would have been impossible, but of course, I don't think they could have established that, but they didn't even try, and they certainly didn't have any testimony to that. The doctors testified that he could have caught this virus anywhere, including at work, and I would submit that the claimant offered more evidence that he was exposed to this virus at work than what they offered that he was exposed to this virus outside of work. They offered.
Was there any objective medical testimony that he was exposed to the virus at work?
No, there's no objective medical testimony that he was exposed to the virus at work, nor was there any medical testimony that he was exposed to the virus outside of work.
Right, and as Judge Marsteller alluded to, I worry that we're creating an impossible burden on the employer carrier to prove a non-occupational cause of a common virus that we can all be exposed to in our daily lives.
Well, I don't think it's an impossible virus. I think that there are situations that viruses have a identifying characteristics that through blood tests you can say this is this particular virus. Perhaps if the Bay County Fair was going on that week and they had people come down with this particular virus, and if they had done a blood test, they could have said, okay, he caught this at the Bay County Fair. That might be possible. Like I said, if he hadn't been at work for a long enough period, and they could develop through scientific testimony what the incubation period is, they would have been able to avoid it. But of course, these presumptions are difficult to overcome. This is the legislature saying, we're going to give this to you, and we're only going to allow the employer carrier to avoid compensation if they can prove, and if they can't, they can't. And with that, I'll save the rest of my time for rebuttal. Thank you.
All right, thank you.
May it please the Court, my name is Alan Kalinowski, and I represent the State of Florida Department of Corrections regarding this workers' compensation appeal. And present with me today at counsel's table is Colleen Cleary-Ortiz, who handled the trial in this matter, as well as Christine Peugeot, who is the Bureau Chief of the State of Florida Workers' Comp Claims. We'll be asking the Court today, Your Honors, to affirm the final order that Judge Rush entered, which determined that the temporary viral cardiomyopathy condition, which was incurred by Mr. Walters, was caused by a stomach virus, namely gastroenteritis, within the 2 or 3 days prior to his admission to the hospital on January 22nd, 2010, which was, Judge Benton, a Tuesday, thus resulting in the denial of his workers' compensation claim. The evidence in the record is straightforward and is largely unrefuted. Mr. Walters was a corrections officer. He worked his regular job through Friday of that work week, and in fact, he was off for the next 3 days as a normal scheduled time off, Saturday, Sunday, and Monday. And he then went to the hospital on his first vacation day, which was Tuesday, the date of the accidents being alleged here in this case. At that time,
opposing counsel told us that it wasn't clear that the JCC had given the claimant the benefit of the presumption despite the stipulation, and that one reading of the order is that he was put to the proof, that a burden was placed on him to prove occupational causation, notwithstanding the predicate for the presumption that had been established by the stipulation.
I'll be happy to address that, Judge Benton. It's very clear from the order and from the stipulations of the parties that the 4 criteria giving rise to application of the presumption were stipulated to. So that level of proof need not be entered into, nor was it required by either party or the court. The presumption, once the 4 criteria are established, shifts the burden to the employer carrier to attempt to present evidence, in this case because there was no evidence produced of work-relatedness by the claimant, by a standard of competent evidence, that there was a non-work-related factor that could have led into it. And so there was no burden.
So you differ with the other side in terms of the burden of proof?
Well, not with the burden of proof, but with the characterization of the burden. The presumption applied. The analysis that the court went into, in addition to the presumption analysis, was an occupational disease analysis, which really, for the lack of a better characterization, provided Mr. Walters with a second bite of the apple on a theory that was not even pled, namely the occupational disease statute. And I think that's where, in their briefs, they misinterpret the judge's trial decision as placing some burden that the judge never placed upon them. She basically gave him another bite of the apple, and the evidence failed even under that theory, an unpled theory.
But that's of no moment, because presumption carries the day for the employee, right?
Presumption carries the day for establishing that they meet the criteria absent evidence of a non-work-related factor, which the evidence, of course, that the court clearly laid out in this case was a gastroenteritis or pericarditis virus that was incurred by all of the evidence within that 2 or 3 days before he admitted to the hospital, days which he was not working, which by definition makes that a non-work-related cause.
He testified that he was not feeling ill at work.
The medical evidence, and I can refer you to the pages of the records pretty clear as to the two physicians' notes that noted when he came to the hospital it was a matter of either 2 or 3 hours or 2 days that he was experiencing those symptoms. After all of that evidence and the evidence and testimony of the 3 doctors who testified in this case had pigeonholed the genesis having occurred within the 2 to 3 days prior to his admission, days that he did not work, the claimant then testified at trial, after all of the evidence had already been taken, that he began feeling not right or whatever during the week before he stopped working, not borne out by the evidence, and the court clearly disregarded that as being inconsistent with the medical evidence, the objective medical evidence. So we believe that the burden of rebutting application of the presumption has been clearly defined out in the court's order.
In your view, what is the burden on the employer seeking to rebut?
The burden of the employer is to establish evidence that is sufficient enough to convince the judge of compensation claims that the claimed condition was the result of a non-work-related cause or factor, as set forth in Vaporis, Punske, and Lentini.
But is that a clear and convincing standard? Is that a preponderance of the evidence standard? What exactly is the burden of proof? I'm looking at the JCC's order, and I'm just going to read a bit of a passage from it. Quote, I find that the claimant has thus presented no competent objective medical evidence that causally connects the cardiomyopathy and pericarditis to the stress of the job as a corrections officer, relying instead on the presumption. I therefore conclude that the appropriate evidentiary standard necessary for the employer carrier to rebut the presumption is that of competent evidence. Is that correct?
That is the correct standard, Judge. When the claimant presents evidence of work-relatedness, the stresses that could be incident to the type of employment, if there's any evidence of work-relatedness that they present, and they're not just simply relying on the presumption itself to carry the day, then the standard of proof for the employer carrier would rise to the level of clear and convincing evidence.
Well, I guess I'm a little confused. Isn't the claimant entitled to rely on the presumption?
That would be
without
true.
Putting on any other evidence?
Well, if the four criteria are met.
That's the purpose of the presumption, right?
Yes, it is, with
it's
the four criteria.
It's an evidentiary presumption. So let's assume, for argument's sake, and evidently what happened here, that the claimant relied on the presumption as is permissible. What then was the DOC's standard of burden of proof to overcome the presumption?
The standard of proof would be competent substantial evidence, because there was no additional evidence brought by the claimant of work-relatedness, a standard that they don't have to meet. But when they fail to produce such evidence, and when there is no such conflicting evidence, the standard of proof becomes competent substantial evidence by the employer carrier to effectively rebut application of the presumption.
What do you do with the Fuller case? I gather you're relying on Punske in that answer, but what about the later Fuller decision?
Well, I think in the Fuller decision, the court uses some language about the trial court eviscerating the standard of the presumption. In this case, the facts are essentially unrebutted. You've got a man who contracted a condition, a virus, 2 or 3 days before he goes to the hospital. The doctors, in an unusual circumstance, in all of these cases that I've litigated, I've never seen all 3 doctors agree as to the cause of the condition. A virus that was incurred in a non-work-related environment. Pretty clear-cut decision for the JCC to rely upon.
Well, now, there's no doctor who said that the virus was contracted in a non-work environment, was there?
Well, they didn't put it in so many terms, but the inescapable conclusion when the doctors say that the virus occurred within 2 to 3 days prior to the hospital admission, and the evidence is that he did not work during those 2 to 3 days, at whatever source, whether it be Walmart with his children, out playing, sitting at home in a recliner, whatever the causative factor at that time was in fact non-work related by pure definition of the evidence, because he was not working.
Well, wasn't didn't any information that the doctors had about the onset of the first symptoms from the virus, didn't that necessarily come from the claimant himself?
Well, it came from the medical evidence. The physicians that treated, or the physician that treated him, Dr. Tratham, took the words right out of Mr. Walters' mouth, and that was either 2 to 3 hours or 2 days before he was admitted to the hospital, he began to experience the discomfort. That history evolved a little bit at the time of trial when he tried to stretch it, he meaning Mr. Walters tried to stretch it to bring it within the ambit of his employment, when that's not what the medical evidence reflected.
Can you point to anything in the JCC's order that suggests that she did not credit any of the testimony of any of the witnesses, including the claimant?
Did not credit or discredit? I'm sorry, I didn't understand the question, Judge.
You're telling us that yes, he actually not only had the benefit of the presumption, but also testified to a work connection. And I believe when you talk about, you claim that he changed his story, so you're suggesting that he was not credible, I believe.
Well, I'm not necessarily suggesting he was not credible. I just think that the statement that he began his symptoms when he testified at trial during the week before he stopped working is completely inconsistent with the medical evidence that the court chose to rely upon. The court can, as you know, select and discredit bits of evidence. They're called upon to do that in the midst of having to deal with multiple pieces of evidence as to which the court's going to rely upon. The court clearly relied upon the testimony of all of the three physicians.
That's my question to you. What is there in the order that suggests that the JCC rejected certain evidence?
The several references to the condition being identified as having occurred in the 2 or 3 days prior to his admission. That clearly establishes the judge relied upon the expert testimony, the medical testimony, and that is a medical question. This is not a lay person decision or a lay person analysis. The doctors all uniformly testified that the condition was caused as a result of a virus within the 2 to 3 days prior to his admission.
So was there medical testimony about the incubation period for a virus?
Well, that might have been an interesting
because all
analysis.
of this, I mean, your argument seems to hinge on the fact that based on that time frame between the time he was at work and the time he started feeling symptoms, that's the critical time frame. So, I mean, in order for the JCC to have made that conclusion, did one or more of the physicians say, and it takes 2 to 3 days to incubate?
Now, there was no showing of any evidence whatsoever brought by the claimant to establish that this could have been a virus that could have occurred a year, 6 months, a week beforehand and had been in some sort of an incubation period that could have then manifested itself during the off-work time. No
but then
showing
that
whatsoever.
doesn't help the DOC, then, right? I mean, then it sounds, I mean, if the virus could have been laying dormant for 6 months, arguably the claimant could have contracted it at work.
I would concede that that is certainly a possibility, Judge, but there was no showing of that. And this case is based upon the decision in this case, and this Court must review the record of evidence. Had they presented such evidence, should that even exist with this kind of a virus? I don't know if there is an incubation period or how long it might be. It's pure speculation from me, and I think, frankly, for this Court to try to impose some sort of what-if on either of the two parties. They failed to bring such evidence. If they had intended to try to establish some sort of watering down of this time frame, they could have done so, and they brought no evidence.
Again, I think the claimant's position is it's not his burden to do that it's the employer carrier's burden because of the presumption. So, I mean, we have to get over that issue first before we can solve whether there is sufficient evidence in the record.
Well, let me address that, Judge Ray, right off the bat. Remembering, in this case, it's a heart disease case. Presumption law covers heart disease, hypertension, tuberculosis. We're dealing with heart disease. It does not cover viruses. Viruses are not covered conditions under the law. This is an ordinary condition of daily life. And that is, in this case, under these facts, what the medical experts uniformly have testified was the cause of this man's heart disease in this case. Kind of an unusual set of circumstances that doesn't occur very often. So it's not the employer carrier's burden to prove that the virus was not contracted outside of work. But to the extent that this court may interpret the case law to impose such a burden on the employer carrier, as I suggested.
Well, but in Caldwell, the physiological cause was arteriosclerosis. In LeBanc, there was some kind of electrical problem, probably of genetic origin. So isn't that a comparable situation here?
I would respectfully suggest it is not, because, for example, in LeBlanc, you're dealing with an electrical problem, which is a cardiac problem that led to an arrhythmia problem, another heart problem. In this case, you've got a heart problem that the medical evidence established was caused by a non-cardiac problem, by the way, by the evidence, incurred in a non-work time frame. And so I think the cases, and I've reviewed the cases that were cited in opposing counsel's briefs, and LeBlanc is clearly inapplicable and clearly distinguishable under these facts. We're not trying to establish one heart condition as resulting in another. We're looking at the evidence that showed that this man's heart condition was caused by a non-cardiac, non-work-related condition of ordinary life, namely a virus.
Isn't there evidence in the record, Dr. Whitworth's opinion, that the claimant had viral cardiomyopathy, and there is a stipulation that, in fact, that was covered, that he was entitled to the presumption? How is that any different than this Court's decision in LeBlanc?
Well, again, cardiomyopathy is a heart condition, and so it was stipulated that that particular condition is, in fact, a covered condition, namely heart disease, falls within a broad ambit of what generally could be referred to as heart disease. The genesis of that, the cause of that condition, was established to be the virus. In LeBlanc, you had one heart condition causing another heart condition, and clearly the Court, I think in a well-reasoned opinion, reversed appropriately in LeBlanc, but in this case should affirm the JCC's decision in finding that the employer carrier has sufficiently rebutted application of the presumption by competent substantial evidence that's clearly set forth in the record. Thank you, Your Honor.
Thank you, Mr. Kalinowski. Rebuttal.
Thank you, Your Honor. First of all, of course, we're not seeking compensation for a virus. The virus is really a red herring in this case. They stipulated to heart disease that was compensable under the presumption. Perhaps they could have chosen a different line of defense, and we may not have known what would happen if they had. Maybe they could have said, this virus is what really, and they could have approached it from the virus, but instead they approached it from the heart disease. And once they accept the stipulation, they have to show a non-work-related cause. They never did. The JCC never found that the presumption was rebutted. The reason we say that JCC put a burden on us was because she did. She never ruled that they had successfully rebutted the presumption because they offered no evidence to show that this virus was not work-related. In their brief, they illustrate their mistaken view of the law when they talk about there's a cardiomyopathy that can happen due to sudden emotional impact. You see a traumatic event. And they put in their brief, if this guy had seen a fellow corrections officer killed in a prison revolt or something, that might be covered. But if he had witnessed one of his children or something in a traumatic death, that might not be covered. Well, what they're doing is, if the presumption applies, we wouldn't have to show that he saw another correction. They would have to show through testimony and evidence that it was something other than being work-related. They did not do that.
All right, but he says that the chronology shows that there was no relationship to the work.
Well, of course, first of all, they didn't present that argument to the JCC. They didn't develop the medical testimony. The medical testimony, the history that the claimant gives to the docs, and what the doctors say is that for 2 or 3 days prior to him reporting to the hospital, he felt ill and didn't feel right, and it was finally so bad on Tuesday when he did report that he was concerned and he went. And the incubation period isn't 2 or 3 days of feeling bad. The incubation period is 2 or 3 days of not feeling anything. You just feel completely normal, but you have this virus growing, and then you become sick.
Is that in the record, or did you just make that up?
What is that for 2 or 3 days he didn't feel well, and he was at work. And so I guess, the rest of it would just be within the scope of Google. But we would ask that you would reverse the ruling of the JCC and find that the presumption was not rebutted. There's no evidence in the record to rebut. The JCC didn't make a finding that was rebutted, and find the claim compensable. Thank you.
Thank you, Mr. Hawks. All right, now with this, the panel is going to switch out. We're going to leave the podium here, and you're about to get here's some 3 real Cracker Jacks.